Our next speaker is Mr. Zachary Gaver. He comes to us from Steptoe Johnson in Houston. Mr. Gaver is a graduate of Miami University, and he got his Juris Doctorate from Capital University. Please join me in welcoming Mr. Zach Gaver.
Thank you all. Thank you all for coming today. I'd like to also thank Brent and all the North Dakota Law Review for having me today. It's my first trip up to North Dakota. I'm originally from Ohio and now live in Houston. So this is definitely a new experience for me, but I've enjoyed myself so far. And I am an associate at Steptoe Johnson PLLC out of Houston. We have offices in West Virginia and Denver, primarily in the Pennsylvania and Ohio regions. And to clear up any confusion, Brent said, well, I saw you guys at a career fair in San Francisco last summer. I didn't know you had a presence out there. And the short answer is we don't. There's also a Steptoe Johnson LP based out of Washington, D.C., and they focus primarily on international law. So if you Google Steptoe Johnson and you wonder why an international law firm might come up, you're not the first one who's had that problem. I definitely was confused at first as well. So today I'm going to be discussing the Duhig principle. And the Duhig principle is what happens when a grantor conveys more than he or she owns as far as mineral interests go. And primarily today, my main goal is just to introduce you to the rule, if you haven't heard it, to be able to recognize when the problem exists and then how to correct it if in fact you've discovered that a Duhig issue exists. And I don't want to bore you to death, and I want to be done on time. And so if I can do those two things, normally I feel like we've done okay. So first I'll introduce what is Duhig. And then we'll discuss how to identify when we have a problem. We'll talk about some examples to try to reinforce the principle. And it's important to note there are some exceptions to which a court won't even apply the overconveyance rule of Duhig at all. The mini workshop part is a complete lie. We don't have that today because this was from a previous 75-minute presentation, and today I've only been asked to do 60. And then we'll talk a little bit about a state-by-state comparison. We'll talk about North Dakota, which is actually my favorite approach to the rule. I think it's the best, and I'm not just saying that because I'm in North Dakota. I actually do think that North Dakota has taken the best approach to resolving Duhig problems. And then finally, what to do to try to prevent these problems from happening and how to cure them if we do have a problem that's already happened. Now, the first 4 bullet points will deal almost entirely with Texas law because Texas is the first state to rule on this issue, and they're kind of the foundation on it. So we have to talk about Texas for a while, and then after that, then we'll move on to the state-by-state comparison, and we'll discuss the other states and the differences between how their courts have addressed the rule. Well, first I have a short video, and the video is not going to be directly on point to what we're talking about, but hopefully it'll be a little entertaining and it'll kind of introduce us to what's going on in the subject.
Have some fun with that truck. Okay, time's up. Here you go. That's a nice one. I made that.
A piece of junk.
Yeah.
I want the red truck.
Well, you can't have the red truck. See, that was a limited time offer only. It's right here in the fine print.
Even kids know it's wrong.
So, obviously this isn't completely on point, right? We're talking about, this is personal property. He's changing out a nice shiny red truck for a cardboard truck. So it's not completely on point. But the Duhig rule of overconveyance is dealing with scenarios when a grantor conveys more than he or she owns in a mineral interest. So in essence, the grantee is getting something less than he or she thought they were getting. And grantees obviously want you to think they've been taken advantage of, and as we will discuss later, this may or may not be the case, but either way, grantees are getting less than they think they're getting. So This happens more frequently because grantors of mineral rights to others a lot of times don't mention the prior reservation that previous owners have reserved on the chain of title. And this may lead the buyer to believe that the seller owns all the minerals mentioned, or more than they do own, and in fact this may not be the case. Now this is why Duhig was adopted to try to make the grantor or the grantee whole and to correct the problem of the overconveyance. So let's take a look at the actual case of Duhig v. P.V. Moore and see how it worked. On the case itself, and I should stop and tell you, for convenience, whenever I talk about O, I'll be talking about the original grantor, the first person in the chain of title. Second, when I say the second grantor, I'll be talking about the second person, which in this case would be Duhig, who's granting to P.V. Moore Lumber. And whenever I say the grantee, I'm talking about the last and final person in the chain of title. So O, original grantor, the second grantor is the person in the middle, the grantee is the last person. So in Duhig v. P.V. Moore, O conveyed to Duhig and reserved 1/2 of the minerals. Duhig then conveyed to P.V. Moore, also reserving 1/2 of the minerals. And it's important to note that Duhig did not actually reference the previous mineral reservation that O made when O conveyed to Duhig. So on the deed itself, it just says Duhig conveys to P.V. Moore and reserving 1/2 of the minerals. So what did the court do here? Well, under a normal analysis, we would say O is going to keep his half. Duhig also reserved 1/2. So why shouldn't Duhig keep 1/2? And then finally, P.V. Moore is left with nothing. Well, the Texas court decided that wasn't fair and decided to adopt what would later be known as the Duhig rule, as we call it now. Texas court said, well, O's interest will remain untouched at 1/2. However, when Duhig conveyed all of the minerals, reserving 1/2 and not disclosing the prior reservation, he was essentially warranting the other half to P.V. Moore because this was a warranty deed. So the court said, we're going to give the other half to P.V. Moore, and then Duhig will be left with nothing. And so the language the court adopted was that where full effect cannot be given to both the interest granted and the interest reserved, priority will be given to the interest granted. So in this case, it would be P.V. Moore's half. Duhig would be stopped from claiming that half interest that P.V. Moore will be able to claim. So Duhig is based off a breach of warranty theory, which comes from Estoppel by deed, and we'll discuss that a little more later, but you'll see as we go that courts use the Estoppel by deed principle in order to justify applying a Duhig rationale later. That's kind of their starting point in their opinions. So when exactly do we have a Duhig problem? We have to know when to be able to identify it. Well, in the first deed, we have to determine the mineral interest that is outstanding, and this is of the original grantor, which would have been O in our first case. Secondly, what is the mineral interest purportedly being conveyed by the second grantor to the grantee? What is the interest reserved by the second grantor? And then we add them all together, and we come up with the outstanding mineral interest. This might seem complicated just looking at it abstractly, but if we move on, we'll be able to discuss exactly how to look at the Duhig principle and apply when we have a problem. So the mineral interest conveyed. We've already said that when Duhig warranted the minerals, all of the minerals to P.V. Moore and reserved 1/2, the court said he was, when he conveyed to P.V. Moore, reserving 1/2 of the minerals, warranting the land, that he was essentially warranting the other 1/2 of those minerals. So in this case, the mineral interest conveyed is going to be a half from Duhig to PV Moore. The interest reserved was a half as well. Duhig reserved 1/2 of the minerals. The outstanding minerals, as we know from O, were a half to begin with. So what happens? We end up with 150%. And we know we can't have 150% of mineral interests. And so it's impossible for us to give credit to more than 100%. So when we have more than 100%, we know we have a Duhig problem, and then we have to move on and try to determine who's going to get what. So we come back to the rule where full effect cannot be given to both the interest granted and the interest reserved. Priority will be given to the interest granted. The two main steps we'll follow here is that O's interest, the original grantor, O's interest will always remain untouched. And then the grantee's interest comes out of the second grantor's portion, in that the second grantor will be stopped from claiming the share of the minerals they attempted to reserve. So we have to look at it from the grantee's point of view. What did the grantee expect here? And our goal is to make the grantee whole. That is the policy and the reasoning behind why the court did what they did. So applying the rules, we can see O received a half, Duhig ended up with nothing, and PV Moore will end up with their half. So let's look through a couple more hypotheticals, and maybe this will help reinforce it in your mind. So let's say that O conveys to A and reserves 1/3 of the minerals. A then conveys to B, reserving 1/3 of the minerals. Now, when A conveyed to B, reserving 1/3 of the minerals, and he didn't mention the prior reservation, he was essentially warranting the other 2/3 that he is purporting to own when he's conveying to B. So what we end up with is a scenario where O reserves 1/3, A reserves 1/3, A conveys 2/3. This adds up to 1 1/3. We have more than 100% interest, and so we know, in fact, that we do have a Duhig problem. So, step number 1, O's interest remains untouched. O receives 1/3. We'll never touch O's interest. B will get the 2/3 that A purportedly conveyed to him when A reserved 1/3. We have no minerals left, so A is left with 0. And we'll see this in mineral deeds. It's common when the second grantor just simply copies an old deed, and it might say, reserving herein 1/3 of the minerals to the grantor. Well, if the second grantor just simply copies that language again, then we're ending up with a scenario where we could have a Duhig issue, and the parties may not expect that at all. So let's look at another one. O conveys to A, reserves 3/8 of the minerals. A conveys to B, reserving 1/8 of the minerals. So we have O's reservation being 3/8 is the outstanding interest. We have A reserving 1/8, and A purportedly conveying to B 7/8, because by reserving only 1/8, he was purportedly warranting the other 7/8. Now our total is 1 3/8. We have more than 100%, so we have a Duhig issue. But the problem here is that even though B may be entitled to 7/8, we know that A could only own 5/8. So what's going to happen here? Well, B is just simply going to be out of luck for the remainder. O's interest untouched at 3/8. B will receive 5/8, which is the entirety of what A owned, even though B will not be able to receive all he may be entitled to receive from A. He's going to receive all that A can possibly give him. A ends up with 0. Hypothetical 3. So far we've looked at hypotheticals that leave A with 0. This doesn't necessarily have to happen. A's interest can just simply be reduced. It doesn't necessarily have to be extinguished. So let's say O conveys to A, reserving 3/8 of the minerals. A conveys to B, reserving 7/8 of the minerals. So we see O reserve 3/8, A reserves 7/8, A purportedly conveyed to B 1/8 because he reserved 7/8 and didn't mention the prior conveyance. So we total 1 3/8. That's more than 100%. We have a Duhig problem. Well, we know O's interest in step 1 will be untouched, 3/8. B's interest will be 1/8, the interest that A purportedly conveyed to him. Well, A's not going to lose all his interest here because there's plenty of minerals to go around, and he's going to end up with 1/2 left. One final hypothetical before we move on, and this is an example where we can have an issue where Duhig exists, but when we apply the rule, it doesn't actually have any real immediate effect. So let's say O conveys to A, reserves 7/8 of the minerals. A conveys to B, doesn't reserve anything, doesn't mention the prior outstanding interest, doesn't try to reserve anything to himself, just conveys the property in a warranty deed, warrant and defend. So do we have a Duhig issue here? Well, yeah, we do, because O reserves 7/8, A reserves 0, but A purportedly conveyed the whole. So our total is 1 7/8, and we have an issue because we have more than 100%. We know that O's interest will remain untouched. But here's where it's interesting, because the most that B could have received out of this at all was 1/8, because we leave O's interest at untouched, is completely untouched. So B is going to get that 1/8, even though A may have warranted the entire mineral estate to him. The only thing A had to give at all was 1/8, and A wasn't trying to reserve anything in the first place. So A is going to end up with nothing, as we'd expect, but B is going to end up with way less than he'd expect. And the Duhig rule has had no impact, because this would be exactly how we would have treated it if we weren't applying the Duhig issue at all. And that is important because it's important to note that Duhig is a shield, not a sword. B is not going to go out and be able to sue O and get the minerals. It's not going to happen. O's interest is going to be untouched. What B could do is sue A for money damages, which you would expect him to be entitled to. But he's not going to be able to actually go out and acquire this property. It's more of an Estoppel principle, where the previous grantor will be stopped from denying B's interest. But it's also important to note that after acquired title could apply. And so if at some point A receives any interest from O, and A is warranted the minerals to B, that interest is going to immediately inure to the benefit of the grantee, which is going to be B. So if at any point A receives some more of the mineral interest from O, that is instantly going to go to B. In theory, might have to file a suit to get it declared. So we've talked about when we have a Duhig problem and what to do to determine who gets what. Well, this is the part where we discuss when Duhig won't be applied at all. And we've only talked about warranty deeds so far. And there's several scenarios where Texas courts, and I don't think there's anything contrary to this from any of the other states, have found that Duhig won't be applied at all in certain scenarios. The first are quitclaim deeds. Now, Duhig rests on a breach of warranty theory. It's based right on the warranty language on the face of the deed. And by definition, quitclaim deeds don't actually warrant anything. So, Duhig cannot apply to quitclaim deeds. And we'll talk about this later. This is one way that Grantors, second grantors, can protect themselves if they choose by using a quitclaim deed. Oil, gas, and mineral leases. And courts aren't going to apply Duhig to oil, gas, and mineral leases at all. And in the case of McMahon, which is the first case, the court considered custom within the industry and found that applying Duhig rationale to oil, gas, and mineral leases would be bad policy. And the reason is that since lessors frequently execute oil and gas leases purporting to cover the entire estate, they may only own an undivided fractional interest. And applying the Duhig rule to leases here would be unfair because so many leases are boilerplate and just say all my right, title, and interest. Partition deeds. In order for Duhig to apply, there must be some type of conveyance of a mineral interest. Well, again, by definition, a partition deed merely dissolves a tenancy between the parties. It doesn't convey anything. And so the Duhig rule is not going to apply to any partition agreements. This one gets a little more complicated, and it's express provisions of royalty, bonuses, and rentals. Courts will not apply the Duhig rule to provisions of royalty, bonuses, and rentals. And our case here is Binge v. Scharbauer, and in Binge, O conveyed to Scharbauer, reserving 1/4 of the minerals. Scharbauer then conveyed to Binge, save and accept 3/8 of the minerals, and 3/8 of the payment of all bonuses, rentals, and royalties. So we have our quarter interest here outstanding from O. We have S reserving 3/8, S purportedly to convey to B 5/8, because he only mentioned the 3/8 reservation to himself, and S actually owning 3/4. Well, we know we have more than our 100%, so we know we have a Duhig problem. Well, if we apply Duhig, what happens here? Well, the court said we're only going to apply Duhig to the mineral interest. We're not going to apply it to the bonuses, rentals, and royalties, and we'll get to why in a second. But first, just running through how we would treat this, we see that if we apply Duhig here, O is going to end up with 1/4, Binge 5/8, that's what was warranted to him, and Scharbauer 1/8, what's left over. Now this is the mineral interest only. It's the same analysis as we were looking at in the previous hypotheticals when we're dealing with mineral interests. The court said we're not going to apply the Duhig rule to bonuses, rentals, and royalties. And so we know that O's interest will remain untouched at 1/4, but we're going to give credit to Scharbauer's reservation of 3/8 here for the rentals and royalties, and we're going to let him keep his 3/8. Binge will then get what's left over. So the reasoning for distinguishing here between the mineral interests and the bonuses, rentals, and royalties was contractual, and the court stated, "But are not the owners of such interests in the minerals free to agree, if they desire to do so, that their fractional interests in bonuses, rentals, and royalties under leases executed shall be in different amounts from what they normally would be?" So even though this reservation was in the deed itself, the court is saying these rentals and royalties are not part of the deed. We're going to just consider this a contractual agreement between the parties, even though it's in the deed. So the court has determined they will not apply Duhig to bonuses, rentals, and royalties. Contractual reasons. For all purposes, and this is our magic language, and you can see in Harris v. Windsor what the deed reference was. And this isn't a description, but for the purpose of disclosing that the deed was subject to prior restrictions in another deed. And the court has found that when this language is used and references another deed, then in fact they will not apply Duhig. And it might seem a little funny because it seems like, well, wouldn't the parties be on actual notice anyway? But we'll get to that in a second. So I guess you would call that super actual notice, I guess. So what we've done so far is we've discussed what Duhig is, when we have a problem, how to fix it, and then when we just don't apply it at all. And in our second part, we'll talk a little bit about the state-by-state comparison, but I also have a short little video before we start that may seem similar to the first one.
Would you like a pony?
Yeah.
Would you like a pony?
Yeah.
Here you go. This is for you.
Oh, that's fun.
Yeah.
Well, you didn't say you could have a real one.
Well, you didn't ask.
So we have our another poor little grantee not getting what they were promised. So moving on to the second part of the presentation, the states, generally how they've adopted it. Well, first I should say, as I mentioned earlier, everything that we've covered up until this point has been Texas law. Texas is the foundation for the Duhig principle. And so moving forward, we'll talk about how different states distinguish their Duhig principles away from Texas. And you'll see that the overconveyance rules in various other oil-producing states are going to kind of fall into two separate categories. And those are states that have either adopted the rule or applied some type of principle, and states that don't yet have a law but use estoppel by deed principles upon which Duhig is based. We'll discuss why we think that quite possibly if a Duhig issue was to come up in those states, that they would probably adopt some type of Duhig policy. Thus far, it just hasn't happened yet, and they've never had to decide. And you'll also see a theme as well between the two, and that the states in the first category that have seen Duhig issues and had to make a decision one way or the other tend to be historical oil-producing states. And the states that don't yet have a law tend to be some of the newcomers, such as states like my home state, original home state of Ohio, who really hasn't had a lot of production past the turn of the 20th century until very recently. So, the first one we'll talk about is Arkansas. Now, Arkansas has been pretty consistent with Duhig. They've expressly adopted the rule, but stated that the rule could be limited for subjective considerations. And what exactly those subjective considerations are, we don't know, but that just seems like a court's favorite language, right? And so, Peterson v. Simpson is our case. In 1938, O conveyed to A, reserving half of the minerals. We had a couple conveyances in between. In 1948, C conveyed to D, reserving one half of the minerals. We have some more conveyances in between, and finally, H conveys to I, doesn't reserve anything. So, I put the dates on because I think it's important to note here that this case is from 1985, and our first conveyance is 1938. Nowhere in this case or anything online could I find exactly what the date was of the deed where H conveyed to I. But if it was in the 80s or sometime around there, I think it's kind of interesting to note that we could be looking at a 40-year window as to from when the start of our Duhig problem began to when the suit actually took place and was resolved. So it's pretty much what we'd expect. O's interest is untouched at a half. I is going to receive a half. C is left with 0. But the court said, we're using an objective interpretation in this case, but we're not going to confine ourselves if there's a future subjective interpretation. And They said it doesn't change the general rule that subjective considerations may be taken into account. I'm not exactly sure what that means, but I have a good idea that they may be thinking along the lines of North Dakota's approach, which I think is actually the most fair, and we'll get to that a little bit later. But in the meantime, we'll just say that Arkansas is going to only apply it objectively and then leave the door open for them to maybe throw a curveball at us at some point in the future. Colorado has applied Duhig, but not by name, and there does appear to be some reluctance upon courts in Colorado to fully embrace the Duhig principle. Our Colorado case is Brown v. Kirk. O conveyed to A, reserved a quarter of the minerals. A conveyed to B, reserved a half of the minerals. Well, A's interest is a quarter. O's interest is a quarter, I'm sorry. A's reserving a half. A purportedly is conveying to B a half. So our total is 1 1/4. We know we have a Duhig problem. And O's interest will remain untouched. B will end up with the half warranted to him from A. A will end up with the remainder, which is a quarter. So in Brown v. Kirk, the Supreme Court actually applied the Duhig principle. It didn't expressly adopt Duhig. Later then, in Appling, an appellate court recognized Duhig was applied in Brown v. Kirk, actually by name, and said it represents application of the Duhig principle. But at the same time, the court actually didn't use Duhig and didn't apply it. They stated that they refused to consider the Duhig issue because one of the parties had not taken the proper procedural actions. So the court just dismissed the case and didn't apply the Duhig doctrine. So for Colorado, I think the bottom line is the court has applied Duhig in theory and not referenced it by name at the highest court level, and we could probably expect that would happen again, but it is important to note that seems to be some reluctance on the part of the lower courts, maybe in Colorado, to fully apply the Duhig principle. Now in Kansas, we have explicit adoption of Duhig, but in an unreported case, and we'll get to why that's important in a second. So the case in Kansas is Grabs v. Dixon, and we have a scenario where O conveyed to Dixon and reserved 2/3 of the minerals. Dixon conveyed to Grabs, reserving 1/16 of the minerals. Our interests are 2/3, 15/16, and 1/16. We know that's well over 100%, so we have a Duhig issue. O's interest will remain untouched. Grabs will receive all of Dixon's interest. What was warranted to him was 15/16, but all he can take is what Dixon owns, so he'll only get 1/3. Dixon will be left with 0. So we have a pretty straightforward Duhig, and the court said that it appears logical and provides a method of construing deeds consistently. But our problem is that this is actually an unreported case, and based on the rules of the Kansas Supreme Court, it's not binding precedent. It's only persuasive. But we do know we have at least one court in Kansas that likes the Duhig rule, even if the other ones don't have to follow it. But we do have a Kansas statute that appears as though it could be pretty favorable to any Duhig rule, and it doesn't necessarily list the rule entirely, but it does provide a pretty good framework for a Kansas court if they were ever wanted to cite to the Kansas statute. So Kansas seems pretty favorable to Duhig, but there's just not enough there yet. And but there is a statute. Louisiana, it's not cited by name, but the rule is applied the same as in Texas. And our Louisiana case, is Dillon v. Morgan. And at the trial court level, the court actually didn't properly apply the principle. But it does provide an example of what a lot of people mistakenly think that the Duhig rule, how it should be applied, where we just kind of, well, if everyone's confused, we'll just kind of split the interest half and half and call it a day. And that's actually what the Louisiana trial court level decided to do. So O conveyed to A, reserving half of the minerals. A conveyed to B, reserving a half of the minerals. This is exactly the Duhig case out of Texas. The same facts. But the court said, okay, O's interest will remain untouched. We'll follow the first rule. But they looked at it as more of a deed interpretation case and said, well, when A reserved a half, he was reserving half of his half interest, which is a quarter. He wasn't reserving the whole. So we'll give effect to A's reservation as it applies to half of his half interest. We'll give A his quarter, and thus B will only be able to receive another quarter. Well, the Court of Appeals in Louisiana reversed and said this just isn't proper application of the Duhig rule. And then Louisiana reached the result that we would expect, where O's interest is untouched, B receives what was warranted to him from A, and A is left with zero. And so we do have a consistent application from Louisiana as far as Duhig in Texas goes. And although it's only at the appellate level, we don't have any contrary authority thus far to suggest that higher courts in Louisiana wouldn't apply it as well. New Mexico is interesting because the Duhig case was cited by name in New Mexico, but the court then decided that there was no reason to apply it. And the reason is that the interests actually added to 100%. We have some reservation issues, but what we ended up with was 15 30-seconds and 17 30-seconds. That equaled 100%. So we actually didn't even have any overconveyance issues in the New Mexico case. And various articles and literature has claimed that New Mexico has adopted the rule. And I don't know that I would call it adopted unless there's another case that I'm not aware of out there. But it seems to me that they've just mentioned it, haven't actually adopted it, haven't actually applied it. I would just say that New Mexico probably would apply it, but if they would apply it the same way as Texas would, we don't really know. Next is North Dakota. And North Dakota, this is one of my favorite movies, by the way, so I had to put it on there. North Dakota has expressly adopted Duhig, but with some limitations. And the limiting case was Gilbertson v. Charleston. And North Dakota has actually written what sounds a lot like the Duhig rule into the title standards. And the title standard that exists in North Dakota is where full effect cannot be given to both the interest conveyed in the granting clause and to the interest reserved because of a previous interest. Priority will be given to the interest conveyed. So that's a shortened down version of it, but it's 3-07 if you're interested in looking it up, and it sounds pretty much like the Duhig rule. Well, in the Gilbertson case, which is our famous North Dakota Duhig case, what happened was O died without a will, and the property goes to A, B, and C. They each get a third. Well, as we see is title examiners all the time, B and C then convey to their other sibling, reserving half of the oil and gas. A bought out his two siblings. And what happened here was that A argued he was entitled to 50% of the interest because when When A received the conveyance from B and C, they reserved half of the oil and gas. Well, A's argument was, by reserving half, you warranted the other half to me, and so I should have a greater interest. So A was essentially arguing that he was entitled to 50% of the interest rather than 50% of the 2/3 being conveyed to him, or 1/3. And the court said, well, you knew of the other mineral interest because you owned it. This shouldn't have been confusing to you. And so the North Dakota court seemed to kind of carve out a little exception there for prior interest owners who happen to be the grantees. And in later cases, the North Dakota court has reaffirmed full support for Duhig and said that Gilbertson was merely just a very small, narrow exception, and that they would continue to enforce Duhig except for the small exception. And it's why I think it's the best approach to Duhig, because North Dakota is willing to take into account very obvious wrongdoings or just obvious problems that a lot of states, and we'll see later with Wyoming, just say, nope, what's on the face is on the face. We're not going to look at anything else. Doesn't even matter if the other guy owned it. But North Dakota is willing to take this approach that is a small exception in order to increase fairness. And when Arkansas said subjective considerations may be considered, this is kind of what I had in mind. I think is probably the North Dakota scenario they're thinking of. Something very obvious. They want to leave the door open to be able to apply and not give a windfall to someone who doesn't deserve it. This may be the subjective consideration that Arkansas had in mind. Oklahoma cites and applies Duhig the same as Texas. There's really not much difference as far as Oklahoma goes. The case is Bryan v. Everett, and it just states when there's an overconveyance, the grantor is stopped to claim that the deed conveyed a less estate. So basically the same language. Wyoming has expressly adopted Duhig and appears to be what we'd think is probably the strongest state in favor of the Duhig principle, and that there will be zero subjective interpretation, just none at all. So we have where O conveys to A, reserving a quarter of the oil and gas. A conveys to B, reserves a quarter of the oil and gas. As part of this same transaction, though, it's important to note, B executed a mortgage to A. In this mortgage, B acknowledged A's outstanding interest. And so, what we'd expect here with traditional Duhig, the mortgage aside, we would expect that O's interest would be untouched at a fourth, B would receive 3/4, A would be left with 0. But wouldn't we expect it to be different because of the notice B admitted? B said, I'm acknowledging your interest in an instrument that was executed along with the deed, the security interest back to A. B acknowledged this interest. And so we may think that we should expect a different outcome, but we're not. The Wyoming court applied Duhig completely and said that notice is completely irrelevant. And they stated that it's highly probable the purchasers in previous cases knew the mineral interest existed there too, but we're looking only at the warranty deed, nothing else, even if it's really obvious. And they actually cited the Duhig, Texas case and almost looked at it as binding precedent rather than persuasive, even though it's another state's law. So Wyoming seemed very eager to apply the Duhig rule, and we could expect Wyoming to fully embrace the Duhig principle no matter how obvious of a problem there may be in fairness there. So we have estoppel by deed states now. We've talked briefly about how the two categories come together, and we have states that have adopted Duhig or some version thereof, and we have the states who have never had a Duhig problem in front of them, but then apply estoppel by deed. All these other states that I'm going to discuss have estoppel by deed principles, which would allow them to lay the groundwork for Duhig application. And as I mentioned earlier, a lot of times in these cases, the Louisiana case as an example, we see the court citing estoppel by deed principles, and then they come in and then say, okay, and we can justify the Duhig principles application based on our already existing estoppel by deed principles. And so you can see there that the estoppel by deed definition it sounds a little bit like Duhig. It's not all the way there yet, but you can see how a court could use that as authority. And as I mentioned earlier, the estoppel by deed states, Montana, Nebraska, Ohio, and then there's Pennsylvania and West Virginia as well. These tend to be some of what we could think of as the younger states with oil and gas production, especially Ohio and Nebraska. And they just don't have a lot of oil and gas law to begin with. Montana has some more than Ohio and Nebraska. But there just isn't a lot out there already, and so we definitely would not necessarily expect them to have a wide array of Duhig cases on point. But a little more surprisingly, from a historical perspective, are Pennsylvania and West Virginia. They've produced a little bit more than, say, like in Ohio. But they also haven't adopted any type of Duhig and of Duhig rationale. But they do have the estoppel by deed. Is precedent. So we would expect probably those 5 estoppel by deed states to adopt some form of Duhig if they ever do encounter that issue, which you think that at some point with the drilling that is picking up in all those states, that they would have the opportunity to decide a Duhig case. It's also important to note, though, that in West Virginia there's an operation of conveyance in excess of actual interest is the title of a statute. And so it sounds like it's some type of overconveyance statute they have, and it would provide and also some framework for a court to cite to that statute, as well as their estoppel by deed principles, if a court wanted to adopt some type of Duhig rationale. As far as policy goes, why does it even matter what we're talking about here? Well, the arguments for Duhig are we want to protect purchasers. We want purchasers to buy with confidence. We want them to feel comfortable purchasing land. And we want to encourage these transactions. But the arguments against are that, and probably what a lot of you may have been thinking the entire time, is that the examiner in the court must usually completely ignore constructive and actual notice. These deeds that were of record, we're just going to say they don't matter, almost. And so the issue becomes, well, the courts with Duhig has taken a very narrow approach of saying we're just going to look at the warranty deed and what it conveyed. We're not going to worry about what the notice that they may have been on had they examined the prior instruments in the chain of title. And the other issue is that it may give the grantee more than he or she bargained for, like the little girl with the horse. Well, if she didn't know she had an opportunity to get a big horse, then maybe it shouldn't matter in the first place. That's an argument also against. So are grantors out of luck? Well, the good news is for grantors, they're not out of luck. There's certain preventative solutions that grantors can take. First, we know they can use a quitclaim deed. Quitclaim deeds are not subject to the Duhig rule, so if a grantor uses a quitclaim deed to convey an interest, a Duhig issue can't come up. Obviously, this may be undesirable to the grantee if a grantee wants a warranty deed. So there are other ways, like we discussed the for all purposes language, and then you reference a prior deed. That's going to get you around the Duhig principle. Additionally, language accepting a specifically described interest. So just go ahead and identify the previously reserved interest. Instead of stating in your deed, grantor hereby reserves a quarter of the minerals, use the language, grantor hereby reserves a quarter of the half mineral interest, thus making it clear that the grantor only had a half to begin with and is reserving a portion of that interest. And then finally, if you want to get a little bit more in depth, you can put language in accepting in a general manner all previously recorded mineral interests. So that's what grantors can do to prevent the Duhig problem from ever happening. Well, what can we do after the problem has already happened? And this is what title examiners are going to recommend. Title examiners are going to recommend a stipulation of interest and cross conveyance. And the stipulation of interest needs to be recorded to give interest to notice to third parties. And then this is going to be contractual between the parties. The parties will be bound to it. And so that's your first step, and then your division orders need to reflect the interests of the parties as well. And in the stipulation of interest, all the parties who may have an interest need to be included. So it needs to be A, B, and C convey to A, B, and C in the following interests, and then you can list out A, B, and C's interests. But it's important that everyone with a potential interest is included in the stipulation. So if you don't want to do a stipulation, what else could you do? Well, you could create a corrective deed for every deed in the chain of title. Seems pretty difficult to do, could be pretty expensive, and especially if there's some errors that you have to track down, which would probably be the case if they're old deeds. So that's one way to do it. It's probably not the best way to do it. And the second is to file a suit to quiet title, which also seems like it could potentially be more expensive than a stipulation. So those are just some other ways that you can cure the problem, but stipulation is probably going to be the best bet. So as far as recognizing Duhig issues, this is just kind of a quick little checklist. And are these slides going to be available to anyone? Okay. So if you, it's kind of just some basic principles you can use in order to recognize Duhig issues. And it's everything that we've already discussed. It's just kind of summarized for you. And then also there's a checklist. And you can use this checklist and go down it, and all four must be met for there to be a Duhig issue. If one of them's not met, there's likely not going to be any Duhig issue at all. So if you access the slides that the law review puts up online, you can copy this for your own reference as well if you want. And then I have one last video for you.
Would you like to go for a ride in that bike?
Okay.
Okay. Whoa, yeah. See, the terms require you to keep the bike in this predetermined space. If you want to take the bike out, I'm going to have to charge you a penalty.
I can't really ride in this little space.
Well, you can't ride very far.
Okay, so I can't really stretch that one at all to apply to Duhig. It's just funny, and it goes in line with some of the other ones. I could kind of stretch the other ones, that one not really. But if you have any questions or you have any Duhig issues, feel free to contact me. For some odd reason, I'm interested in this subject, and so I'd be happy to discuss it with anyone. My contact information is up there. I'll also be at the reception tonight. I can give you a card if you'd like. And also, if for some reason you're not able to access an electronic copy of the slides online and you think they'd be helpful, just please get with me and send me an email, and I'll be happy to get them to you. Thank you for having me. Oh, questions? Should we ask questions? Right. Right, and that it's based on a warranty claim. And it's also important to note, though, that B's not going to probably be able to acquire more land. It's more of a mechanism that prevents A from claiming that land if B is already, using the land or claiming to own it. But I say A receives this, B receives this, just because it's simpler. But you do have to realize that, it's a shield, not a sword. And so it's based on Estoppel principles. Anybody else? All right, thank you.